The foundation of your protection in the UK is the Consumer Rights Act 2015. This law states that any term in a consumer contract must be fair. If a term is deemed unfair, it is not binding on you. So what does unfair mean? An unfair term is one that puts the consumer at a significant disadvantage by creating a major imbalance in the rights and obligations of the parties. It's the legal system's way of saying that a company cannot use its power to write a one-sided contract that you are forced to accept. Let's look at some of the most common unfair terms you'll encounter. First, we can change the price at any time. A company cannot give itself a blank check to change the fundamental terms of your agreement without a valid, specified reason that you are made aware of from the start. A clause that allows arbitrary price hikes is a classic example of an unfair term. Second, we are not liable for anything that goes wrong. These are called exclusion clauses, and they are heavily restricted. A company can never exclude its liability if its negligence causes death or personal injury. And they cannot use a blanket term to avoid their responsibility to provide goods of satisfactory quality or services with reasonable skill. The law gives you those rights, and a line in the T&CS can't take them away. Third, you are not permitted to leave a negative review. These gagging clauses are almost always unfair. The law protects your right to share an honest opinion and experience. A company cannot legally stop you from telling the truth about their poor service. And fourth, all disputes must be settled in a court in a foreign country. A term that forces you to go to extraordinary lengths or expense to resolve a dispute is likely to be considered unfair and unenforceable. So what does this mean for you? It means you are not powerless. When you have a dispute with a company, don't let them simply point to a line in their terms and conditions as the final word. The law looks beyond the fine print. It looks at what is reasonable and fair. If you believe a term is unfair, you can challenge it. You can tell the company that you believe the term is unenforceable under the Consumer Rights Act 2015. If they refuse to budge, you can take your complaint to an ombudsman, or, if necessary, the small claims court. And in that setting, a judge will not care what the company's terms say if they are fundamentally unfair. Terms and conditions are not a form of legal magic. They are a contract, and that contract must be fair. They are designed to make you feel like you have no rights, but the opposite is true. The law was written to protect you from the very overreach that these documents often represent. So the next time you click agree, do it with the knowledge that your real rights are not written in their fine print. They are written in law.